All right. Well, hopefully some of this will not be too simple for you. I thought start with the background to one of the most important things that people don't realise when they're looking at trademarks for their new beer or their new brewery. It's that a trademark is not the same as a company name, a business name, or a domain name, or for that matter, copyright. You can register just about anything as a company name or a business name, even if it's almost identical to something that someone else has already got. It's only if it's actually identical that you can that the ASIC, Australian Securities Investment Commission, will actually stop you. Trademarks, on the other hand, are completely different. That if you've got a name that's even similar to an earlier name that you're trying to register, then the Trademarks Office should prevent you from doing that. Having said that, you can have the same name, like Penfolds is a wine, it's a stationery supplier, and it's a car seller. That's because the trademarks registers divide up into 45 different classes. So it's only if you're in competing goods or services that you'll be refused registration. So we'll come to those classes later on, looking what the beer class is. But the important thing just to remember is the fact that you're able to register a company name or a business name or even a domain name doesn't give you any right to use it, that name. It's only if you register the trademark that you actually have the right to use the name. Copyright's also intellectual property, but that's outside the scope of what we're going to talk about today. So what can the trademark be? Obviously it can be words. It's pretty straightforward. It can be the logo that you want to use. So we're going to hear from Callum about KAIJU. So the monster KAIJU, that's functioning as a trademark for KAIJU. It can be a slogan. You can if you've come up with what you think is a great slogan and it's not descriptive of your product, you can register that, which means you can stop other people using the same slogan. Distinctive colours. It's probably going to be hard with beer to come up with a distinctive colour scheme unless you use it for an awful long time, like Cadbury with purple, or if it's really weird, like pink for pink bats a few years ago. Shapes can be registered. Now that might be the actual bottle shape, so you got the Lucky beer here. It could be the shape of your label, if that's particularly distinctive, or any other form of presentation or whatever you're using in your marketing. Sounds and smells, a bit more relevant to perfume, Harley Davidsons, that sort of stuff, but who knows. As long as you can represent it graphically, and that might be by way of a formula or a graph or whatever, then it's potentially registrable as a trademark. Some good names for if you're coming up with a new name for beer or brewery. Invented or obscure words are the best, because there's no reason why they won't be registered, and if someone tries to come up with something similar to trade off your reputation, then it's going to be much easier to stop that. Suggestive words are the next best. So elephant, implying that it's big or strong. So you've got Carlsberg elephant beer, stronger beer. You've got the Delirium, the Belgian beer with the pink elephant on the front. Again, sort of, it's suggesting something about the contents. Yeasty Boys, again, sort of suggestive of the one of the ingredients, but play on words with obviously Beastie Boys fans. Arbitrary just means it doesn't really relate to the product in question. So, example, they're little creatures, nothing to do with beer, but it's a distinctive, memorable, good brand. You can have descriptive words if it doesn't relate to the product. So the classic example in trademark law is North Pole for bananas, because obviously no one's actually going to be growing bananas in the North Pole, so therefore it's not descriptive. And goes without saying almost, but it shouldn't be similar to an existing brand. So the bad names, the things to avoid, which most people completely ignore, they come up with, if you look through the list of brewers, you'd probably see at least half of them would be using one of these. So a common surname, because if there's more than 750 people on the electoral roll with that surname, the Trademarks Office won't register it. B, if you use your surname, someone else comes into the industry and they've got the same surname, you can't stop them using it. Descriptive names are bad. So anything that's describing either the product or even ingredients of it. So, you know, you've got Malt Shovel Brewery, but then you've got Malt Shed, you've got, there was another malt one. All of these words that sort of play on the ingredients, you run into the danger that other people are going to use something similar, and then you're going to have the likelihood of confusion. Geographic names are also bad for the same sort of reason as surnames are bad, that, if you come up with, say, Burnley Brewing, and someone else sets up a brewery in Burnley, they're going to call themselves Brewers of Burnley or something like that. And if everyone's trying to call out that local as part of their business name or trademark, you're just going to have people totally confused. So I had a case last year between Noosa Brewing Co and Noosa Brewery or something like that. And I won't go into the details, but other than to say it was a shit fight, and the only people who won out of it were the lawyers. Laudatory, so generic names is a bit like descriptive names. So if it's just describing the product, laudatory words, again, if you're saying best or super or whatever, you're just not going to get it through registering it with the Trademarks Office, and if you can't do that, then you can't protect it, and so sort of what's the point? And then deceptive names. So if you called something low alcohol and it's actually high alcohol, or something like that, or gluten-free beer and it's actually got gluten in it, even though that's sort of, again, they're descriptive and generic terms, but also if it's claiming something about the product that's not true, then it's not going to be allowed. So you get that coming up with the geographic names as well, where the Trademarks Office will require an endorsement to say, if you're calling something Adelaide Gin, for example, which is a matter I've been working on, they have an endorsement that says it can only be used on gin that's produced in Adelaide. So why should we be saying, well, it's good if you can register it, it's bad if you can't? Well, trademark registration is actually the only way that you can assert a claim to ownership. So talking about proprietary rights, anything short of a registration of a trademark, and you don't really have anything that you can say that you own. You can put the little R in a circle, but that's not a huge thing, because if it's not registered, you can use the little TM sign instead. But if you're in that situation where you've only got what's called a common law claim because you don't have it registered, if someone else starts using something that's very similar and you want to take action against them, it's really hard and really expensive, even more so than any other type of court case, because you actually have to prove that you've got reputation in that name. And if you're small, you might have reputation in, say, the surrounding couple of suburbs, but not even throughout the state, let alone throughout Australia. If you've got a trademark registration, you don't have to prove that at all. You don't even need to have brewed your first beer to be able to stop someone else from using the name if you've got it registered. The other thing you've got to do in taking action against someone is prove damage. So say, say you've got a brewery, say KAIJU in Melbourne. Callum's been going for 6 months. Someone in Queensland sets up one called KAIJU, and Callum doesn't have it registered. He's got maybe a reputation within 10 square kilometres. The guys in Queensland, doesn't matter how much they sell locally, Callum's not actually going to suffer any damage because he's not losing any sales, because all the locals are still buying it. and the locals up in Queensland are buying it. But if he's got it registered, he doesn't have to prove any damage. All he's got to prove is that the name is deceptively similar to his, and doesn't have to prove any actual confusion, only that it's likely to cause confusion if someone comes across the two names. So that last bit, sword and shield, is just a little moniker for saying that. So the sword is saying that you can stop someone else from infringing your registered trademark, and the shield is the protective benefit. So if you've got your trademark registered, no one else can come and say that you're infringing their trademark, as long as you're using your mark as it's registered. So it has that added benefit of giving you peace of mind that your brand, your mark that you're using is not going to infringe someone else's, and you're not going to get sued by them. Okay, so how do you go about making sure someone else hasn't already got a similar mark to the one that you're looking to use? Well, you need to search for what's already out there. In terms of trademark searching, you can do it yourself, and I'll come to those slides in a minute, but there's always tricky bits to it, so it's in my best interest to tell you should be using an expert like me. But you need to, if you are going to use an expert, don't just go to them and say, oh look, here's 10 names I'm thinking about, tell me about those, because you're going to get a massive bill. What you need to do is even if you're not going to rely on all this yourself, at least have a go at doing it to narrow down the field of the names that you might be tossing up between. So in terms of searching the trademark itself, it's a website run by IBA Australia called Australian Trademark Search. Just a tip, it works really badly on mobile phones and tablets. You need to go old-fashioned with a proper desktop. I'll give you the site when we come to it. But the other thing to do, even if someone doesn't have their beer registered, but maybe they've been making it for 3 or 4 years, it might be tap room only, do a search across like Rate Beer, Beer Advocate, Untapped in particular, because that seems to pick up a lot more of Australian beers that aren't necessarily widely distributed, and even look at Dan Murphy's. So I had, about sort of 2 years ago, a guy was setting up a new brewery on the Mornington Peninsula, and he'd come up with this name, which was sort of geographically descriptive, but it was sort of a local reference rather than a formal reference. And he checked the trademarks register, and there was no names like that on there, applied for the mark, and then found out 2 weeks later that in fact there was another local producer had been using that same name for about 2 years on a taproom beer only, and then ended up being like 18 months of fighting over who was entitled to use it. So it is important to check the use in the market, even if it's not registered. So doing it yourself. If you go to IP Australia and just look, Google trademark search, you'll come to this page. Now this is not particularly helpful. This is called their quick search page, where you can type in a name and it'll search across all 45 classes, and it'll give you all the trademarks that have ever been applied for, whether they're registered or not, or whether they've lapsed. But if you go up into the top right-hand corner where it says Advanced Search, it brings you to this page. Now, apologies that this is all small, but this is just basically a screenshot of the web page, and I'm sure the slides will be available afterwards to look at it more closely. So this is all unfilled, but if you look at the if we go forward, okay. We seem to have frozen. Okay. While the screen's being advanced, the top left or the top of the page gives you a choice of either searching on the word or on the image. And when it says image, you actually type in, you might type in hops or elephant or something like that, and just wait a moment and it will give you a drop-down list of their formal classifications they have. Or if you have a logo that you don't know how to actually describe it, you can upload the image by going through this top right section. So you put in the word and then you'll see the drop-down list after that has part, prefix, suffix, or exact. So the idea is that you sort of say, I was doing this search for like Pacific, as in Pacific Ale. So type in the word Pacific, or you might type in PACI and then prefix. And then you come down to just where the, above where the red circle is at the moment, it says class. And so if you're looking for beer's in class 32, but the Trademarks Office considers that most alcohol is the same. So class 33 is all alcohol other than beer. So it's best to search across 32 and 33, because if you have a very similar name that you're applying for in class 32, and there's an existing wine, for example, or a whiskey or a rum in class 33, then the Trademarks Office will reject your application. Now you can't see anything, but below that there is a section that talks about the status of the mark. So it defaults to all, but if you click on that, you can have like pending, which means it's going through the system, or pending and registered, which means it's going through the system, or it's already registered, because unless you're a particularly curious person and you want to know trademarks that used to be registered or that people tried to be registered, then you don't need that information. Although, having said that, if you look at ones that come up as lapsed, not accepted, that usually means they didn't get registered. They weren't even accepted by the Trademarks Office. So that might be a tip for you if you've got something similar that you're not on the right track, because there's a reason why it's been refused. Okay, that is probably all I was going to say about DIY searching, and then I was going to talk about the actual process next. So you've got the traditional form of applying for a trademark, and this is all done online nowadays. So you type in, all of your applicant details, the sort of goods that you want to, here we go, the goods that you want to have registered, and so on, and apply. But then what happens is that the examiner's not going to look at that for about 5 or 6 months, and most people want to know a lot sooner than that. So there's a new process called TM Head Start, where it'll be looked at, they say, within up to 4 weeks. At the moment it's around 3 to 5 business days, and you get an instant response where they say, yeah, this will probably pass, in which case you pay the second part of the fee, and then you get a formal examination within 4 weeks. So all up, you're going to find out in about a month. If you're not in a hurry, you can go the normal route, which costs about $250 less. Sorry, about $80 less on the government fees and $250 less if you're using a trademark attorney. And once it's been examined, as long as it's all clear and the examiner says, yep, go ahead, it then goes into an opposition period where anyone else can oppose the registration. They need to be obviously looking at what the new applications are that are being filed, but if you subscribe, for example, to the Brews Newsweek email, you see that comes around the monthly listing of all the new applications in Class 32 that have been filed. If it gets through opposition because no one's opposed it, or you go through an opposition and you succeed, then it goes to registration. Registration gives you 10 years protection. Actually, I think that's my next slide. I'll come to that. It takes a minimum of 7.5 months from applying to getting registered. that's because the government signed up to a treaty that says they'll allow 6 months for anyone from overseas to file an application and get the protection date of their original overseas filing. So generally it's more like 9 to 12 months as sort of a minimum. The government fees, $250 per class. Unless you're doing contract brewing, I wouldn't worry about class 40, which is for brewing of beer, because your brand is going to be going on the actual beer, which is class 32. There's other things you might want to do, like if you're doing merch, you might want to be in class 25 for t-shirts and stuff like that, but that's sort of, that's ancillary. I think that's generally, you know, most craft brewers can't be spending additional money they don't have. And then whatever trademark attorney you're using will charge fees on top of that. Okay, so in terms of the opposition process, I'm going to throw over to Pete to give you his war story.
Thanks, James. Is this on? So, as James said, I wanted to give you the war story about what happens when it goes to shit. So we, I came up with Wayward as a name. I was very excited. I registered the trademark on the website myself. Actually, at the same time, registered it in the U.S. and Canada and Great Britain, and had visions of doing beer all over the world. We recently started a registration process in China, but Callum's going to talk about his war story in China, so I'll leave that bit to him. So, this doesn't look like it's right. Yeah, we've missed a slide out. Yeah, there's a couple slides missing. Anyways, so registered it, and I get this letter from a trademark attorney in Melbourne saying SAB Miller India is objecting to our trademark. Now, so that's bad, that's not what you want to see. So I very quickly then said, well, I need an attorney to help me with this. So I engaged an attorney in Sydney, protested about how broke I was and didn't have any money and was just starting the brand. So they were doing some work for another company I was involved in. So they were providing me with some good advice, but not too expensive, and started telling me about what the process was. So in February 2013, I got the notice of opposition. Then what happens is that there's a process of, then the opposer has 6 months to actually provide evidence to support their claim. And basically, there's a slide missing that basically had all the things that they were accusing me of doing. And essentially it was everything. I was trying to deceive the public. I didn't own the trademark. I wasn't intending to trade. So that's what's called throwing the book at us. Yep. And the kitchen sink. I'm sure James probably would have done the same thing. Yeah. So basically, you're doing everything bad. You're an evil person, and you're trying to deceive people. But essentially, what their main claim was that and that were the same thing, right? And obviously, yeah, we're totally trying to fool the public with that. I mean, Jesus, we were really trying to trying to pull a fast one. So then going back to this process, so they had 6 months to do that. Then we have 6 months to respond to it. Their evidence in support was pretty lame. They don't even have a trademark in Australia. So they can oppose it even though they don't have a trademark. And they were like, well, people in Australia buy our beer, right? And they gave sales that they'd sold, 100 cases of it in the last year or something like that, right? It was pretty lame. But so we had the choice of just saying, fine, let the trademark office decide this, but then we risked, when people don't provide any evidence, what's your experience with that?
It shouldn't make a difference, but I think it does. It's the same. You don't have to put in an appearance when it comes to the final hearing, and you don't have to put in submissions. But I think it makes it easy for the examiner or the hearing officer to find against someone who doesn't put in any evidence, because it looks like they don't really care, and therefore no one's going to jump up and down when there's a bad decision made. Yeah. So that was my advice that I'd taken as well, was that we didn't have to file anything evidence in response, but if we didn't, it probably meant that, well, there's really not a second chance with this. So we did a lot of work to do that over that 6 months. Probably cost us in the range of, all up, this whole process probably cost us in the range of 10 grand, right? So a year and a half, 10 grand, and complete waste of time, really. So then we did that. Then 6 months, they get to actually respond to your response and say why it's not valid. And then, so that's again about a year later. We did they did do a Hail Mary, which was sort of like they saw that they had a shit case. So they wrote a letter saying, oh, well, even though you're doing this, we'll let you use your logo if you sign this release form and let us register. So that was that letter. They said, you can use your logo. That was an old version we had. So we said, dear Davies, Collison Cave, it's the lawyer. Thanks for your kind offer. Please go fuck yourself. That may not have been the actual letter that went back. Because it was my trademark attorney that was writing the letter back, and although that's what I instructed her to write, she wrote something a little bit more tactful. Would you have written that back, James? We're actually bound by a duty to be courteous to our brethren. So I'll probably just ring up and pass the message on verbally as given, and then send a more polite version.
Yeah. My client has instructed me to tell you to go fuck yourself. However, because of my duty of care, I can't say that. Again, there's another slide missing here, but so we won the case, which was a massive relief. That was like us, we for almost 2 years didn't know whether we were going to be able to move forward. We were moving forward anyways, but if it was denied, we would have had to go back and start from scratch. So when we won, we said, hey, well, we need to release a beer to kind of celebrate this. So I wanted to have the word victory in the name. So we were looking at a couple of different, decals, and this one might have been pushing it a little bit too far. That was certainly the advice I got. So we went with this, and we called it Fusami. I did have an elaborate backstory about how the Fusami tribe was this tribe in Central Asia that invented beer 10,000 years ago. People did see through that pretty quickly that Fusami actually stood for fuck you, SAB Miller India. Anyways, that's my war story. Is Callum coming up now, or are you gonna come back? You good? Yeah. All right.
Probably, I'll just transition there. Probably the thing that Peter didn't mention there, so he won, it cost about 10 grand, and I'd say you probably were able to claim costs about 2,000.
Oh, yeah, that was the other. That's one of the slides that's missing is the letter that we got awarding costs of about, under 2 grand. Yeah, so even though, it was a frivolous case that had no basis and we had to defend it and all that kind of stuff, the costs are awarded on this schedule that bears no resemblance to actually what things really cost. So that was really frustrating.
Yep. Okay. So having got past the situation that Pete was in and got the trademark registered, you then get 10 years protection. And that can be renewed as many times as you want for further periods of 10 years. So at the moment, the renewal fee is $400. So in the scheme of things, it's not too bad. So $40 a year for protection, compared that to, for registered business names and company names and that sort of stuff. Now, this has to be borne in mind, it's a territorial or a country-based system. So the whole process we've been talking about only provides you with trademark registration in Australia. If you want to go overseas, if you're just going to, say, one market, then it's probably most cost-effective to use a local trademark attorney in that market to do the registration. But as soon as you're doing more than one market, then there's a system called the Madrid Protocol, which is agreement between, there's about 100 or so countries that have signed up to it, which allows you to file one application which goes through the WIPO, the World Intellectual Property Office in Switzerland, and then they send it out to all the different countries that you've nominated. So you sort of go through and tick the boxes of the countries you want. The fee is about $800 Australian for the base fee, and then you pay per country that you've ticked the box for, and that varies from less than $100 for some of the European countries, Denmark, France and so on, and even New Zealand's around 100, through to most of the countries around sort of 400. US is a bit more. Japan, you've got to pay a second fee, so that ends up being around $700. EU's around $1,200. And so these automatically get sent off to those local countries, but then they go through the same process as if you were applying in the local country. So it's examined by an examiner, it's open to opposition, and so on. And if there's any problems in those countries, then you end up having to retain a local lawyer, because the Trademarks Office won't let foreign lawyers deal with it. So on that note, this was just a quick one, an IP Australia seminar that ran last year, was talking about registering in China and the problems with Trademark Squatters up there. And this slide just talks about how a company had been selling its products up there for quite a few years, and then all of a sudden they heard from their distributor. The distributor was being sued for trademark infringement by a Chinese company that claimed to own the trademark. I'm reading all this going, well, that's actually my case. I'm sure there's quite a few of them, but so the one I had was a Tasmanian wine producer who'd been selling mainly sparkling up there. Their distributor of 10 years got amazed to get this writ from a provincial Chinese court out in the countryside, saying that they were infringing the trademark, and Amazon was actually a co-defendant because the wine was being sold through there. So fast forward about 3 years, we've had to run about 4 different matters up there, like a trademark removal case, a trademark cancellation case, trying to get our own mark registered, and defending this infringement case. So the fees, I think, are around probably 40 grand. These guys make sales of less than 10 grand a year up there, but it's they just got sucked into this whirlpool, and not sure how to get out of it. But let's hear from someone who's gone through this himself. Callum.
Yes, suffice it to say that we've never availed ourselves to the services of the Madrid Protocol. About a year ago, I guess, I got an email from someone that I know who works at the Australian Embassy in Beijing in the IP department, actually, and he had received, I think he'd received an email from someone in a local market who'd seen these designs coming up in social media and clearly being poured at places and stuff, and this was clearly a concern. I don't know if you don't know, this is a exact direct copy of some of our designs. In many of them, and so they've called themselves PP Monster, PP Monster, or I don't know, and so some of them they've removed our logo, but one of them they didn't even bother to delete the word kaiju from the actual imagery. So of course I was very concerned about this. It wasn't the best news, and I received a similar email from someone else in China a couple of days later. I think there might have been some relation there. Obviously, this is really a difficult situation because we were selling in China some time ago, and so the situation is basically how much do I commit to this, to being able to defend the rights to the imagery of our brand and our branding in China. And just to show you that they had actually also registered those images as well as the word kaiju in China as trademarks. So the images you've got there, that's a logo. We don't really use this logo anymore. It's our original Monster. It was originally Monster Mash and then a kaiju logo. Monster Mash was another whole story. IP. Kaiju is just a long series of trademark issues. But they also registered the image for the Aftermath Double IPA as well as the Metamorphosis. That's probably the biggest issue for us. And we haven't really registered imagery before either, which might be it might be foolish, but it's really hard. It's hard for me to conceptualize how to protect our trademarks in terms of imagery. How can I describe what I'm protecting? The image itself is a powerful tool, but anyone's ability to copy that and market it is kind of a little bit up to them. But yeah, it's really at what level do you stop registering? Because for us to have protected our trademarks from this kind of issue, we would have had to have registered names and all images and registered them in the markets through the Madrid Protocol. And we're talking, for us to be really well protected, I don't know. I mean, I would think it'd be hundreds of thousands of dollars to get the level of protection across our suite of what is valuable to us. And really what we do when we're developing a brand is what parts of this are irreplaceable and valuable to us that we need to protect, and they're the bits that we trademark. Anyway, when I got these emails, I contacted my regular lawyer who does have some experience in IP, and part of the process, we then got onto Davies Collis and Cave, and they sort of guided us through the process, and they engaged lawyers in China for us who did a bunch of research into the business. We had a lot of advice about it. Some of the advice was this kind of thing doesn't usually last long in the market. It's generally they'll trial it and then they'll switch to something else in the near future. The other element that we had to balance was how much money are we losing, or how much of our brand are we losing to spend the money on protecting this. And really, we had pretty much decided not to do much more in China. China's a very, very difficult market. It's a lot of fun, but it's a very difficult market, and I don't think it'd be much fun anymore. So at the end of the day, we did some things to set ourselves up in terms of having the full rights to the imagery, because this is designed by an artist. And we don't really own the copyright, so we then had to go through that process with our artist to ensure that we owned the copyright. And I guess we paid probably a similar amount, $10,000 or something like that, in lawyers' fees. And there was definitely some pro bono work in there from one of my lawyers, but. Not a fun thing to have to go through. I guess I don't really know what's the moral of the story here, except that this can happen. It sucks. I guess the better prepared you are, the better set up you are, the less likely this is to happen. But it's really hard to protect yourself from something like this. And James, you might be able to tell us how we do protect ourselves from this, or.
Yeah, I think it's a good lead into. I think it's a good time to take questions, but maybe to lead into that, you can't register and protect everything. I mean, I've got one client who does, but they spend. They're a global company, and they spend. I think they spend far too much money. I shouldn't say that. Well, actually, I've told them that. I said I think you're going overboard with this, but I'm happy to take your money if you want to do that. So I think the question I would ask myself, put in your position, is if I saw this happening, would I sue the person? And if you said, well, actually I'm not going to because it's in a foreign country I'm never going to go into, or, I make $5,000 a year of sales to that market, it's not worth it, then I wouldn't bother with going down the trademark registration route. I mean, one thing to look at might be registering copyright in the images that you use. So I've done that in the US and China for a couple of clients.
Yes, and we've done that now in China, just to set ourselves up for if we ever really did want to pursue that. That was the advice that we were given.
Yeah, because that protects you not just in beer, but if someone used that on cuddly toys or chopping boards or synchrotrons or whatever, it doesn't matter because copyright covers all goods, whereas trademark registration just covers you for beer. So I think you're in a much smaller subset because of the distinctiveness of the artwork that you guys use. One of the things that Callum said is really important that a lot of people don't realise, which is owning copyright in the imagery that you're using in your packaging and your point of sale. I had a case a few years ago where the brand manager for a big wine brand came up with this new marketing program where it's for a Coonawarra winery, and so he said, we'll get the red dirt and we'll spread it on the white cardboard and we'll do like an image of the winery, which is really distinctive. So he did that, got a photographer to do the shoot. It was just for a print campaign, and it was so successful he said, okay, we're going to do this for online and various other things. And so I asked the photographer for a different version of the photos, and he said, well, yeah, but there's a reshoot fee. He said, what do you mean? He says, well, I own the copyright in it. He said, but I came up with the idea, I did all the red dirt stuff and I paid you for it. And the guy goes, well, read the terms and conditions. He said, you've got a license just to use it for the campaign that you told me about. So unless you have something in writing from, whether it's the photographer who does your bottle shots, whether it's the artist who does your logos, unless there's something in writing that says, I assign the copyright to you, all you've got at best is a license, and it may be a restricted license. So that's, we're not talking about copyright today, we're talking about trademarks, but that's me talking as a lawyer. For you guys, you probably think it's the same thing. So it's worthwhile making that point. Do we have any, how are we going for time, by the way? Good.
So in terms of protections with copyrights, is it as rigorous and as strict as a trademark? So if I copyright an image or my logo, does that give me the same protections over that image and logo as if I trademark that image or logo?
In Australia, we don't actually have registration for copyright. So something that copyright exists in, whether it's words or an image, as soon as that's created in Australia, copyright exists in it. And it exists in the creator of the works, unless it's an employee, in which case it belongs to the employer. So the simple answer is no. In Australia, it's nowhere near as rigorous. It just automatically comes into being and you have rights under the Copyright Act. But there are other countries around the world where they do have a registration system. And so US and China, for example, there's no protection until you actually register it.
In terms of the beer industry being, you know, high turnover in terms of new beers, and we're constantly changing, with those beer names, like let's use Aftermath as an example, is there an issue with trademarking branded names like that as well? And if there's someone overseas that have used the same name for a similar style of beer, is that something that you come across?
I think with seasonal and one-off beers, the moral is do the searching and make sure you're not infringing on someone else's name before you do it. But I probably wouldn't be spending the money on protecting it unless and until it looks like it's going to become a core range. If someone's using the same name overseas, not a big deal, because as trademark registrations are local, it's just to the jurisdiction. Say you get a cease and desist letter from them, you just say, look, it's already sold through. You know, I made 600 litres of it. It's gone. I've got a big client that's just gone through this locally where it was I'm trying to work out how much I can say without giving too much away. It was named after a confectionery item. It was riffing on it. It wasn't using the name, but everyone knew who it was. Turns out there's actually another brewery that's already done that with a completely different beer style, but picking up on the same thing. They've registered the name, their version of the name, and I saw the other day that the massive confectionery company is trying to register it in like about 30 classes, and it's been refused, probably because of this beer company in South Australia who's registered it. So, but my guys just went back and said, hey, it was a one-off taproom thing. We only posted one post on social media. We'll take that post down. We've already poured it through. And so, you know, just move on. So, you know, as a trademark attorney, I should be telling you, register everything, but no one's got the money for that. So if it's a one-off, do what I was saying before about the searching. So search through the common law stuff. So, you know, Rate Beer, Untapped, Beer Advocate, that sort of stuff, and check on the trademarks register. But, you know, if it's going to be seasonal and you're going to keep doing it year after year after year, then maybe it's a different idea. But if it's a one-off, if it's a festival beer or something like that, I wouldn't worry too much.
Is there a time limit on, for example, KAIJU, Aftermath? Let's say you haven't made that beer in 2 years, 3 years. It's no longer one of yours that you're producing. What's the time limit before that runs out? So, for example, there's another brewery who makes an Aftermath beer 5 years after KAIJU. And then KAIJU want to put in an objection. Is there a time limit? Or is it depending on how long it was registered for?
If it's registered, then you've got to be using it at least once in the last 3 years. Otherwise, someone can bring a formal application to get that struck off the register. Say they made it as a festival beer and have never brewed it since. There's no formal time period, but I would say run with the same time period that applies if it was a registered trademark, so 3 years since last use. And it's not just last use, but last sale of it.
You're right. Yeah. I was wondering in Aldi, for example, the German supermarkets, they run very close with brands like Jimmy Briggs instead of James Bogues, with very close branding, and same with Stella. They've done one of Brewdog recently with Punk IPA. Is it inevitable that they're going to take some of the best branding in craft beer, in small independent craft beer, and start to copy that? And if that happens, is there any protection, or is it simply the one with the deepest pockets wins?
Yes to all of those. Yes, I can't get over like that the James Squire knockoff and the Stella. I would be taking them on over that, but it wouldn't be my money, so it's easy for me to say that. I think the fact that those companies haven't taken Aldi on is a pretty fair indication that the deep pockets will win.
Do you think that might also have to do with the fact that they're otherwise a customer? There are marketing considerations in these sorts of things as well.
There are, but I don't know how much they'd be putting through Aldi because of so much of their stuff's home brand. Maybe they're doing a lot of contract production for them. I don't know, but they've Aldi did get taken on about 2 or 3 years ago with a shampoo brand, and it was a really, really disappointing decision because the judge said people expect to see knockoffs in Aldi. That's summarising about 200 pages of legal jargon. But before anyone takes them on, I'd recommend they read the shampoo decision, because it was just, as an IP lawyer who likes to see people being able to protect their stuff, it was pretty chilling.
Probably need to wrap it up there, by the way. Any more questions? I guess they can answer this after the panel. But thank you guys for the interesting chat about trademarks. Cheers, everyone.
Thanks, Luke.
Thank you.